My name is Ryan Clinton. I am an attorney here in Austin, Texas. I'm an appellate attorney, which means I'm kind of like a law nerd, I think is the best way to describe my role. When I get involved in cases, it's usually because they're particularly complex or because there's a big number at issue in the case, or after the case is won or lost at trial, I handle appeals. So doing a comprehensive national review of cases involving animal shelters and rescues and their liability was, although not what I would normally practice, in an area I would normally practice, that kind of review is what I do for a living. So it was fun, it was interesting. And the background on this session is that, as I'm sure all of you have we have heard the words, "we can't do that because we'll get sued," right? Over and over and over again, especially in the kind of traditional model of animal sheltering, there are all these restrictions and guidelines and rules. And one of the things very, very, very early on in Austin, back in probably 2007-ish, my wife and I decided that we wanted the shelter, which wasn't doing them at the time, to do off-site adoptions. And we went to the shelter director, and she said, "No, we can't do off-site adoptions. We'll get sued for that." We're like, "Well, we'll sign waivers, we'll do whatever it takes," and the answer was no, 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 no. We also wanted to do adoptions, even when they started allowing off-site adoptions. We wanted to do them on the trail, because the shelter at the time is where Austin Pets Alive is now. We wanted to do them right on the trail where runners are running by every day. And no, we can't do that because of liability. We can't take them anywhere because of liability. All these things, we were told because of liability. And being the smart aleck attorney that I am, I asked what law school the shelter director had gone to. Because, you're being told we can't do something because of liability reasons by people who largely don't have any idea what does and doesn't invoke liability. So, and that was true across the country. In fact, when I started doing this, I don't think there's anybody across the country that had researched this topic, and I'm still not sure. I still haven't seen another person giving this speech at any conference. So it became pretty valuable, and I get a lot of emails, as you might imagine, on this subject. So the whole point of this is to condense it as best as possible so that I can share what I've learned in research in cases across the country. As a reminder, liability changes in any jurisdiction. The rules of law change in any state. Every state has its own state law on liability. Okay, so just because you see something that happens in Illinois doesn't necessarily mean that it's going to be the same law in your state. Also, even within a state, the law can be different in different jurisdictions. So in Texas, we have multiple courts of appeals. And in each one of those court of appeals, the law could be slightly different until the Texas Supreme Court rules on a particular area of law. So I say that because you need to make sure that you don't, the point in this is not to teach you what the rules are. The point in this is to give you the information that you need so that you can then go talk to your attorney in your jurisdiction to make decisions and do the best you can to make decisions to help your organization reduce its liability. There are a couple of chairs in the front. If you guys in the back want to sit down, if you want to stand, that's fine too. But there's still some chairs in the front if anybody wants to come in. Okay, we're going to talk about the basics of liability. I'm going to give you some animal law case studies. This is basically this is the same way as, are there any lawyers in the room? So yeah, 4 or 5. This is how we learn in law school, is we learn some facts of cases and then figure out what the court ruled and then try to figure out what we can learn from that. And then I'm going to give you some lessons and strategies for shelters and rescues. Again, this is not meant to be me telling you what to do. This is you gathering information from these cases from across the country and then you making the decision as to what is the best practice for you. We do not have an attorney-client relationship because I'm talking to you. This is information that is provided to you to give you the tools to talk to your counsel and talk to your attorney and make the decisions for your organization. Always consult a local attorney before implementing legal strategies. All right, so let's talk a little bit about lawsuits. So again, you've probably heard, we can't do that, we'd get sued for that. Well, that doesn't really matter because you can get sued for anything. Your neighbor could sue you tomorrow for nothing if they wanted to. Anybody can get sued for anything. What matters is if you would be potentially held liable for something. That's the thing that you should worry about more than whether or not you could get sued. And liability is the condition of being responsible for a possible or actual loss. That's what really matters. There are 3 causes of action that I see in the case law with regard to animal shelters. A cause of action is basically the claim that they would bring against you if you were sued. One is negligence, and negligence just means essentially you didn't act reasonably under the circumstances. It's the most common cause of action and is in some ways the easiest to prove because you just have to convince a jury or a judge, if there is no jury, that you behaved unreasonably under the circumstances. There's also strict liability in some jurisdictions, and that essentially means that you could be held liable even if you didn't do something unreasonable. Regardless of whether you did anything wrong, you could potentially be liable under the strict liability theory, usually by statute. And third, and we'll talk less about these, but there are a couple of cases, is premises liability. And this is essentially not being liable for the action you took, but more being liable for something that happened on your premises. So, for example, a slip and fall is a premises liability lawsuit. If you were, just mopped the floors and you didn't have a sign out to warn somebody that the floors are wet, that would be a premises liability type lawsuit. So those are the 3 types of lawsuits we see in the case law on animal shelters. The basics of a cause of action or a claim against you are some legal duty that the law puts on you. A breach of that duty, meaning you did something that was that violated the law, the duty that the law placed upon you. Causation, meaning that your action, your breach of that duty is what caused somebody's injury, and then fourth, the injury itself, or how to compensate somebody for the injury. And what we'll see is these are the things that you're going to see in the case law. You're going to see issues of duty, breach, causation, and injuries. And obviously, if we're on the flip side of that, you guys are likely to be the defendants in all of these lawsuits, is you want to be arguing that no, that we did not have any duty to that particular party. We didn't breach any duty to that particular party. Whatever we did was not the cause of the accident or the injury, or the person doesn't even have any injury or damages. So a dog bite without any harm would be you might have done something wrong. A dog may have bit somebody, but if it didn't pierce the skin and they didn't go to the doctor, there are no injuries, there are no damages. And then also we're going to talk a tiny bit about affirmative defenses, which means that even if you did everything wrong, even if it's all your fault, even if the law would otherwise hold you liable for that thing, an affirmative defense means we can just say it's like a get-out-of-jail-free card. And there's one particular instance that matters. There are chairs up front. If anybody in the back wants to, there are plenty of seats up front. I can see about a dozen of them, so you don't have to stand up in the back if you don't want to. All right, so let's start talking about the cases. The first area is liability after adoption, because that tends to be the one that most people worry about the most. We can't adopt that dog out because, we'll be held liable if it bites someone. And so what I try to do is try to be very objective in finding as many cases as I can, telling you what the rulings are, telling you the lessons that I get from those, and then you make the decisions as to how it impacts your decision making. First is Miles v. Rich. This is a Missouri case back from 2011. By the way, I think all of the cases that I'm citing are appellate cases. What that means is that there was a trial, somebody won or lost, and then it got appealed. And the reason that matters is because a trial decision, but an appellate decision is binding on future cases within that jurisdiction. An appellate decision, you're going to get a written opinion, and a trial court decision, you're often not going to get a written opinion. It's just a judgment, and then everybody moves on. So the appellate decisions have more precedential value. If it's outside of your jurisdiction, it's not going to be binding on the court in your jurisdiction, but it could be what's called persuasive, meaning the court could look at it and say, I agree with its reasoning, it's persuasive, even though I don't have to follow it. Here's our prototypical example that everybody's worried about. Humane Society of Missouri adopts out a dog. The dog then bites a third party after the adoption, and that third party sues the owner, who then turns around and countersues, brings back in the Humane Society. So in your instance, it would be you adopt a dog. It doesn't bite the owner, it bites a third party. That third party sues the owner, who then brings you in and says it was all your fault. And the court here holds no liability against the Humane Society because it did not own, possess, harbor, or control the dog at the time it bit. Meaning the shelter was no longer the owner, it is no longer liable. Galgano versus Town of North Hempstead, pretty similar facts. Did I just lose? Can you guys still hear me? Okay, it just turned it down a bit, good. The town shelter, so this is a municipality. So we have the difference between the last case where you had a humane society, a private organization. In this case, it's a town shelter, so it's a municipality. Town shelter adopts out a dog who bites an individual, same fact scenario. The individual who got bit, this third party, not the adopter, but a third party, turns around and sues the city shelter, and the court says no strict liability under New York's dog bite statute because the plaintiff did not prove that the shelter knew or should have known of the dog's dangerous propensity. So if the shelter didn't know, they adopted out a dog, they didn't know the dog had a propensity to bite, then under this dog bite statute, they're not going to be held liable. So, and I think I have a couple of New York cases right in a row. Ty versus North Shore Animal League. Again, dog adopted out from shelter. Here, you have a slightly different fact. It actually bites the adopter, right? So you have a closer relationship with the adopter because you had a contractual relationship with the adopter. The owner then sues the shelter, and again, the court says no liability because even if the shelter didn't warn of the dog's dangerous propensity, the adopter already knew of the dog's character prior to the bite. And so this was a really fascinating case, and I think it probably sets up the law that in a way that makes sense. It said that if the shelter, these are the lessons from it, essentially, if the shelter informs the adopter of the dog's dangerous propensities or the information that the shelter knew about the dog, even if they didn't know it was going to bite, maybe it says it was a little rough with a volunteer, whatever it is they know, then there's not going to be liability if the dog repeats the behavior that the person was warned about. In this case, it was interesting because the shelter didn't warn them, but the plaintiff, the owner, learned of the dog's behavior a long time before the owner was bit. And so if the adopter learns of the dog's dangerous behavior prior to the injury, according to this court, no liability. And this was really interesting, I thought, well written. The rationale for such rule is self-evident. Informing a person who takes possession of an animal about the animal's vicious propensities allows that person to take precautionary measures to protect himself or herself and others from harm caused by the animal's vicious propensities. So the lesson from this, and we'll talk about it later, is disclose. Disclose what you know about an animal. You're going to be a lot less likely to be held liable for a dog bite in the future if you disclose to the adopter every single thing that you knew about the animal. Next, this is another New York case, Lawrence versus North Country Animal Control. Dog surrendered to the shelter for aggression. So we have, again, slightly different facts. I'm deliberately giving you cases that have slightly different facts so you can see how the courts are working through them. Dog surrendered to the shelter for aggression, adopted out again, so it was readopted after it was surrendered for aggression, and then it bit the new owner. Here, the court says the new owner can bring a claim for fraudulent misrepresentation because the shelter downplayed the prior owner's experience with the dog. Remember, we learned from the case before that according to, again, a New York court, that if you disclosed what you knew about the animal, you're less likely to be liable. In the next case, not only did the shelter not disclose everything that they knew, but they affirmatively downplayed what they knew about the animal. And that, in that instance, the court is saying you could be held liable. If you go in and downplay what you know about an animal, and then the animal goes and bites, you're placing yourself at the potential to be held liable. Interestingly here, the court also says that the adoption waiver did not bar liability because the waiver did not expressly waive liability for the shelter's negligence. This is called, at least in Texas, the express negligence rule. And what that rule is that if you have a waiver, the waiver has to expressly identify the parties whose liability is being waived. So if you have a waiver that says you will not hold us liable, it also needs to say for our negligence or other conduct. So it has to expressly state the party whose liability is being waived in the liability waiver. And we don't have many of these cases anywhere across the country where a shelter might actually be held liable, but this is one of them. And the lesson there are two things. Your liability waiver better be good, and when you have information about a dog, you need to disclose it. What about volunteers? Again, back in the day, I was told we can't have a volunteer program because somebody might get bit and we'd be held liable. So I looked into those cases too. Blake versus County of Wyoming. This is another New York case. Volunteer was bit while volunteering at the animal shelter. And the court says no liability because the shelter did not have actual or constructive knowledge of the dog's vicious propensities. So again, we have a slightly different facts, right? We're not talking about an adopter or even a third party. We're talking about a volunteer. But the same rules apply. If you know something about a dog, you need to disclose it to your volunteers who are going to be interacting with that dog. Because what you don't want to do is put someone in a situation where they do not know to take the precautionary measures to protect themselves. If you disclose the same information to your volunteers that you know about the animal, you're a lot less likely to be held liable. Morris versus Best Friends Animal Society. This is one of the more recent cases that I found. A volunteer was attacked by a dog, severely injured by a dog while volunteering at Best Friends Animal Shelter. And the court held that there was no liability because the volunteer had signed a waiver of liability. And I actually requested the liability waiver from Best Friends, and it does include an express negligence provision, meaning that it specifically identifies Best Friends as being the party whose negligence the party waiving liability is waiving. Brown versus Northwoods Animal Shelter. Volunteer slips and falls at an animal shelter and then sues the shelter for liability. I mean, certainly everybody who runs an animal shelter knows that this is a risk at any given time, that somebody could fall. Note, so this is a premises liability case, which I talked about earlier. Premises liability is where they're suing you not for your activity at the time, but for some condition of the premises. And the court held no liability because the volunteer had signed a waiver of liability. So make sure that your volunteers are signing waivers of liability. Fire Insurance Exchange versus Cincinnati Insurance. Here we have two insurance companies fighting over which of their clients essentially would be liable. Dog bites a 12-year-old child volunteering at a private humane society. The child's parents sue the humane society, which insures the humane society, who then countersues against the parents, I think, and then we have two insurance companies battling out. And the court held that two things that are important here, or a huge thing that is important here. The parent's signature on the liability waiver did not defeat the claim because the shelter may be deemed to have violated child labor laws by requiring the volunteer waiver for a child. Okay? So this is a giant red flag that you have to make with respect to your shelter, is whether or not you want to potentially be liable for a child's injury if you cannot waive liability for the child, and a parent cannot. And this is not my area of law. I'm not an employment lawyer, but I did reach out to some employment lawyers who told me very specifically in Texas, it was their view that they would not recommend allowing children to interact with animals who might bite because in their view, parents could not waive liability for their children. So it's up to you. Again, every organization has to make different decisions, and just because they might not be able to do one activity doesn't mean you wouldn't allow them to do a different activity. Or, it's highly unlikely they're going to get severely mauled by a cat. You could have them interacting with cats even though you might not choose to have them interacting with large dogs, bunnies, cats, whatever. So you can make decisions which change your liability calculus, but you need to know that at least one court, and at least at the advice of the lawyer who I talked to on the subject, was that you need to be wary that you may not be able to waive liability for a child. No, you can ask questions afterwards. I have a lot of material that I want to get through, and then we'll do afterwards. Okay, adoption sites. This was another thing. What about our who goes at Petco, PetSmart? A lot of people have adoption sites, right? So what's our liability there? Another New York case. Anybody from New York? You guys must sue a lot. Dog bites prospective adopter who is visiting the shelter. So this is a prospective adopter. The adopter has not yet acquired the animal. Prospective adopter. The court says no liability because the shelter was not aware that the dog had dangerous propensities. So we're seeing that same decision made over and over again. Claps versus Animal Haven, another New York case. Dog available for adoption outside Petco. So here's an example that happens to a lot of groups. Outside Petco bites a Petco customer walking by. So not even a prospective adopter, just a random Petco customer walking by. That customer then sues the animal shelter whose dog it was that bit. And the court there held no liability under the New York dog bite statute because the shelter did not know or have reason to know of the dog's dangerous propensities. Obviously, the lesson there is if you have a dog with a bite history, don't bring them to a Petco, right? Pretty clear. Collins versus County of Vermilion. This is Illinois. And Illinois has a very, very strict liability statute. Dog bit man who stuck his hand into the cage at the shelter. And the court said that case could go forward under the strict liability statute if the man was allowed in the cage. And that statute says if a dog injures any person who is peaceably conducting himself in any place where he may lawfully be, the owner of such dog is liable. So that's the strict liability statute that I know of. I haven't seen it anywhere else. That's essentially a no harm. It doesn't matter whether you did anything wrong. It doesn't matter whether it's the first time or the 20th time. There's going to be automatic liability. I was shocked in reviewing the case law of how many pet custody disputes there are in the case law. There's a really big one in Texas. How many of you are from Texas? Okay, so a good number. There's a really big one in Texas that you need to know about if you don't already know about it. Lamar versus North Country Animal League. This is in Vermont. Dog impounded as a stray for the 9-day stray hold period. Held for the entire period, then transferred to a nonprofit shelter, then adopted out from the nonprofit. Prior owner, who has been looking for the dog the whole time, finds out, is denied the adoption from the shelter that the dog was transferred to, and then sues the nonprofit shelter after the dog was adopted to someone else. And the court said, no liability for public policy reasons. The nonprofit shelter gained complete ownership of the animal after the hold period had expired. That, I believe, is the correct decision. Haynes versus Hampshire County Commission. This is a West Virginia case with essentially the same facts. Dog impounded as a stray hold for 5-day hold period, then adopted out. Prior owner finds out, sues county, and the court says no liability for public policy reasons. Liability would render animal sheltering void. Essentially, if the animal shelter could be held liable for adopting out an animal after the stray hold period. Interestingly, the court noted that the facts may have been slightly different if the animal shelter still held the animal during that time. The court may have, doesn't really say, but the court may have ordered the dog to be returned. Again, I think that's right. If ownership doesn't convey to the shelter after the end of the hold period, then what are we doing? Because every animal still belongs to its prior owner. Shockingly, that is exactly what the Texas Supreme Court held. And yes, a dog was impounded. This is Lyra versus Greater Houston German Shepherd Dog Rescue. Dog was impounded, held for the hold period, then transferred to a rescue group. Prior owner finds out, sues the rescue group. The trial court held. It was reversed by the Court of Appeals in Houston, and then the Texas Supreme Court reversed that decision. Texas Supreme Court says the dog still belongs to the previous owner, despite the fact that it was held during the hold period and despite the fact that it was transferred to another group. This is a big case, and it impacts everybody in Texas. And I have another session on hold period ordinances. But basically, the rule of the case, and I don't have it here, but the rule of the case, the court said that the hold period ordinance, Houston's hold period ordinance at the time, did not expressly transfer ownership after the hold period. Therefore, in the Texas Supreme Court's view, the prior owner did not have notice that its rights would be destroyed if it failed to pick up its dog by the end of the hold period. I think it's totally wrong, doesn't make any sense, but that's what it held. And so the lesson from that case is, in Texas at least, you need to make sure that your hold period ordinances expressly state that title to the animal transfers to the animal shelter at the expiration of the hold period. And we have since amended Austin's so that it expressly says that. Title to the animal expressly conveys or transfers to the animal shelter upon the expiration of the hold period. If not, all of you who are accepting animals from animal shelters could be sued by the prior owner. And think about what that means. Because theoretically, if you walk through the logic, it means you could be sued for giving it vaccines. It means you could be sued for spaying and neutering it. It means you could be sued for euthanizing it if you're a shelter. I mean, really bad and kind of, in my belief, crazy potential complications of that statute or that decision. But if you amend your hold period ordinance to make sure that it says that title conveys, then you should be all right. Fager versus Warwick Animal Shelter. This is another New York case. Prize show cat, allegedly stolen, surrendered to the animal shelter and adopted out to a new owner. Prior owner finds out, sues animal shelter, and this was an anomaly. The court said that the suit could go forward if the plaintiff proved that the shelter knew that the cat was owned and didn't return it. And so in this instance, in this weird case, it was a famous show cat in the area, and the court kind of just assumed everybody could have known whose cat this was. No idea if that's true. And so if the shelter knew whose cat it was and didn't return it, it could be potentially held liable. I think that's an anomaly. I think that's unlikely to be a decision that gets followed again, but let it be a lesson for shelters. If something comes in with an ID on it, make an attempt to return it to its owner. Don't just sit there and wait for an owner to come to you. Make an attempt to return the animal. Okay, various miscellaneous ones. This is a foster case. This is one of the few cases that I've come across in foster. And this is another thing that sometimes Austin Pets Alive comes with me with legal questions, and it often has to do with fosters. If you have a big foster program, which hopefully all of you will after you leave this conference, because you will have learned nothing if you don't learn that foster programs are important. But if you have a big foster program, you're going to lose animals in it. There are going to be people who stop answering your emails and who stop answering your phone calls. Or who move, and you don't ever hear from them. You don't know where they've moved to. You don't have their new address. It's a matter of, it's going to happen if you have a large foster program. So here the dog was in foster, and the foster owner had done a whole bunch of research. And she had done all this research, and she had read all the negative impacts of spaying and neutering, and there are negative impacts of spaying and neutering. And she concluded that she didn't want to have the animal spayed. I think she wanted it to be a show dog. And when the animal shelter came and said, hey, we need to spay or neuter that animal, she said, no, I'm not giving it back. And so they sued her. And the court held that the dog did, in fact, have to be returned to the shelter, which is the right decision. In the notes, in the case, it kind of suggests that the foster agreement could have been better to make clear who owns the animal. So if you have a foster program, you need to have a foster agreement that makes clear who owns the animal and what the conditions of that fostering arrangement are. And then there's I talked briefly about affirmative defenses. And the biggest affirmative defense, at least in Texas and in some other states, but in Texas especially, is governmental immunity, sovereign immunity. In Texas, it is extremely difficult to sue a governmental entity, especially with regard to torts. I actually worked at the AG's office the Attorney General's office in Texas for 6 years doing all appellate cases, and in 6 years I never lost a case. In every single one of those was a governmental entity, a state entity being sued. Very, very hard to sue a governmental entity in Texas. And so the City of Elgin case versus Reagan was the worst facts I've ever seen in a case. And a lot of times lawyers will tell you bad facts make bad law, because what courts will see really bad facts and then they'll just make a decision that doesn't follow all the rest of the law because they feel so badly about that facts, and this could have been one of them. Not all the facts are in the case itself. Some of them I found on contemporaneous news articles. But essentially, the animal shelter, the allegations are that the animal shelter adopted out a former police dog without telling the family that it was a former police dog. The parents tied the dog to a tree on the day that they got it, and a child walked up to the dog and it mauled the child. Dad comes home from work and immediately shoots the dog on the spot. And then they sue the city for adopting out this dog. And that court says, even though they did not tell the parents that it was a police dog, and even though there was some evidence in the record that they knew it was a police dog, court said no liability because of sovereign immunity. You can't sue a governmental entity for that. And that is an Austin Court of Appeals case, so it's our jurisdiction, but it's not a Texas Supreme Court. So it would be persuasive authority in any other court in Texas and binding authority for local jurisdictions. Ex parte, Gillen, loose dog bites resident who sues the animal control officer, same thing, qualified immunity. TBY versus City of Martins, Ferry, loose dog bites minor who sues city, same thing, qualified immunity or sovereign immunity. So there are some cases that are out there where a governmental entity is held to not be liable regardless of anything else because of immunity. All right, strategies to reduce risk. How am I doing on time? Does anybody, what time is it? What time is it? Okay, great, perfect. So here are the basic strategies for reducing, I can't see that. How much? 10 minutes? Okay, I'll be fast. Hopefully. I may be a few minutes late, I'm sorry, it's me, you're welcome to leave. I call it the 3 C's, conduct, contract, and CYA, or cover yourself, insurance, okay? Conduct you can change, right? You have the power to change your conduct, to do things to reduce your risk of liability. Contract, you have the power to have waivers and contracts to reduce your liability, and then if all else fails, to have insurance. Conduct includes if you are not a governmental entity, to incorporate. Just the act of incorporating will reduce your personal liability in any instance, because if you act through your corporation, it's the corporation that has the liability and not the person. An incidental benefit, if you're a nonprofit, is you need to be incorporated in order to get a 501c3 anyway, which I would encourage any rescue organization to do, because then you can accept donations and they can be written off. Adoptions. This is what I tell people. Observe, document, and disclose. Act like you're under oath. You have to tell everybody the truth and nothing but the truth and the full truth. Disclose everything that you know about an animal, and that includes both behavioral and medical. I would actually say that every animal in your system should have a place where people can document about that animal, whether it's in a computer system and all of your volunteers and employees can go into it, or whether it's in a written system, a clipboard in each animal's cage where people can take notes. And you then need to give a copy of that to your adopters, because then you can show that they have seen all of they have all of the same information that you have. Same thing with medical as behavioral. Record and disclose. Warranties. This is a big one. Animal people love to say, good with kids. They love to say that. I forbid you from saying that. If you say good with kids, you are making a promise about the future behavior of that animal. And you are potentially subjecting yourself to liability if that animal bites in the future, because you are essentially warranting or guaranteeing that animal. Don't do that. You can give the information that you have that leads somebody to that conclusion if it's accurate. So you can say this animal was in a home with children and behaved well. If that's accurate, there's no problem with that. But don't go the next step to make promises about how the animal is going to behave in the future. And that is both true negative and positive. Don't say this animal is going to bite you. Don't even say that we don't recommend this home to a home with kids, because what does that mean? You do recommend it to a home with adults. Just disclose the information that you have, and don't go out on a limb making promises about how the animal is going to behave in the future. I saw a hypo in another that somebody had written that was, the shelter said, We don't recommend this animal to a home with kids under 12. And then the 13-year-old got bit. What have you just done? You've warranted the animal for 13 and up, right? By saying we don't allow this for 12 and under. So just don't make those predictions. Just give the information that you have, disclose it honestly, tell the truth, and let people make their own decisions. Adoptions. The premises. Your duty with respect to your premises is to do one of two things for defects. It is to warn people of the defects in your premises or to cure those defects. So if you go into a Walmart and you see a wet floor sign, they are meeting their obligation to warn you of the potential defect. That's why that sign is there. If you go down the highway and it says damage to guardrail, that is why the sign is there. If you go down a street and it says loose gravel in the road, does anybody change their behavior when you saw that loose gravel sign? No, but they have warned you. And if you get in an accident based on the loose gravel, you're not going to be able to hold them liable because they warned you. So that is your duty with respect to premises. Warn or make safe. That's what you need to do. There was one case I found where dogs were routinely getting out of an animal shelter because they weren't locking them up well, and they were held liable to a person who the animal escaped and then bit somebody. So that's another thing. Make sure that your dogs, especially your big dogs, are locked in well. Inspect your gates. If you are a place where people do business, your duty is not only to warn or make safe. At that point, you have an additional duty to inspect your own premises. Most people don't have this with respect to their homes, but if you have a business where you operate out of, you also have the duty to inspect your business to make sure. So you can't say, "Well, I just didn't know about it." And so again, we go back to the Walmart spills. There are cases that depend. The outcome depends on whether or not Walmart would have caught it if they had been inspecting, right? So you have a duty to affirmatively inspect your own premises. Written policies and protocols for volunteers, employees, board members, safety training for employees and board members. Do all of the basic things that any for-profit business would do, you need to have with respect to your nonprofit. Even things like sexual harassment and all the basic things that any organization should do, your organization should be involved in. Adoption agreements. Again, I said this is for contracts and waivers. Disclose everything that you know about the animal. You can say, for example, in a waiver, you may require the adopter to waive the liability against the rescue. You can actually also require that the adopter indemnify you if someone else is sued. So let's say you adopt out the animal then bites a third party who then turns around and sues you. If you have an indemnity provision, that person has to provide your defense. And just so you know, we do have an adoption agreement and a fostering agreement that Austin Pets Alive's brand new, released this week, adoption and fostering agreement is available on the app as part of this presentation. So if you go to the app and you look at this presentation, you can download Austin Pets Alive's adoption agreement and fostering agreement. We're still working on the volunteer agreement, but the foster and the adoption are available for you. I would give you the same warning that I gave at the beginning of the presentation, which is it is not legal advice. Take it, read it, bring it to your lawyer, and talk through all of the issues. Because you may want to make a different calculation than Austin Pets Alive did with respect to how much it wants to assume or require waiver of liability. So you have to make your own calls, but it's there for you to begin that conversation with your attorney. Talked about the express negligence rule earlier. And warn, all animals are inherently unpredictable and may subject the adopter to health or safety risks. That should be in all your contracts. People need to know that. We cannot predict any animal's behavior, so we need to make sure that they're warned. You should expressly disclaim oral promises, because what happens if one of your volunteers says, "Oh, this dog is great with kids." You didn't even know about it. It's not on any of your signs. It's not on your website, but somebody says, "Well, your volunteer or the person who was walking around told me the dog's great with kids." You can require that you can in your contract have an express disclaimer that says that we disclaim any oral warranties or agreements or waivers. And so this adoption agreement is the only thing that's legally binding. You should also consider a mediation or an arbitration requirement. I think APA ultimately decided not to have an arbitration requirement. There are pluses and minuses. Talk to your lawyer about whether or not you want to send any potential lawsuit through an arbitrator first. Foster agreement, same thing. Disclose everything that you know. Require them to waive liability. Make sure that it says that animals are unpredictable and may subject them to health and safety risks. Also, because of that case we saw, make sure that it clearly says that the shelter owns the animal and that the animal has to be returned upon request. Same thing, in fosters, make clear that the animal belongs to the rescue. 5, is that what that says? 5, thanks. Make clear who is responsible for the costs associated with the animal, food, sheltering, medical care. I mean, these are big issues that come up, right? I took my foster to the emergency room and you're not going to pay for it? Are you crazy? Right? Every one of us is going to get that. Well, make sure it's stated very clearly in the foster agreement that we provide the medical care. You don't take it to an ER without our permission, but you provide the food and the sheltering. I would recommend that you require them to keep them on leash or behind a fence so if the dog escapes. This is one thing I was mentioning right before the conference, is that this topic is that your biggest area of potential exposure is to third parties while the animal is in your custody. Because a third party you're not going to have a waiver from, but if the animal's still in your custody, you're still liable for. And that's going to happen a lot in foster. That's the place that scares me the most, is in a foster home. You can require your foster to waive liability, but you can't require your foster's neighbors to waive liability. And so your fosters need to make very smart decisions to keep the animal safe while it's in foster. Volunteer agreement, same deal. Make sure they waive liability, they indemnify the shelter for its own liability, they understand that animals are unpredictable and may subject a person to health and safety risks. And again, I was told that the best practice is adults only. And then finally, insurance. There's workers' comp insurance for your employees. There's general insurance for your operations. That would include your volunteer, your premises, your offsite adoptions. There's D&O, which is directors and officers insurance that insurance tends to be pretty cheap because it's actually really hard to hold a director or officer liable. And then also just your supplemental events. Keep in mind that APA would have liability for this conference if one of you slipped and fell. So even for your events, you may make the call that it's not worth paying insurance for an event, or not worth paying insurance for something. But you need to at least be mindful of the potential places that you could be at risk and what you can do about it. I don't know if they're here this year, but Frost Bank or Frost Insurance through Frost Bank does insure animal welfare groups, and so at least that's one company that I know you can call. And that's it. So I have like a minute or two. I'm happy to answer questions. I will also wait out here. I will wait outside this room so the next group can come in. I will wait as long as I need to answer as many questions as you have. So thank you.